Looked at this morning.
Yeah, I know. I did too. I sat down and looked up and said, oh, there's nothing there.
All right, good morning, everybody. This meeting of the Escambia County Planning Board for August 5th, 2025 is hereby called to order with 5 voting members present. We do have a quorum. Just a reminder to please put your phones on silent or turn it off either way while we're in the meeting so we don't have any disruptions. And if you would, please stand and join me in the Pledge of Allegiance.
Justice for all.
All right, thank you. I'll note we do now have 6 voting members present as he makes his way to the front. Do we have proof of publication?
Yes, sir.
Did publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement. Is there a motion? Got a motion. Do we have a second? We have a second. All those in favor, please signify by raising your right hand. All those opposed? Motion carries. Rezoning meeting minutes from the previous board meeting dated July 1st have been provided to the board. Are there any additions, deletions, or corrections? Seeing none, I'll entertain a motion to accept the rezoning meeting minutes into evidence. Is there a motion? Second. All right, motion is second. All those in favor, please signify by raising your right hand. All those opposed? All right, motion carries. The rezoning hearing package for today's meeting, August 5th, 2025, with findings of fact, has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into evidence. Do I have a motion?
So moved.
Do we have a set? All right. All those in favor, please signify by raising your right hand. All those opposed, motion carries. All right. Will the court reporter please swear in members of staff?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
To affirm.
Or so you do affirm.
All right. And the board has previously qualified staff to offer expert testimony in the area of land use and planning. Does anyone have any questions regarding their qualifications and ability to offer expert testimony? All right. Seeing none, we're good to go there. Okay, at this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners, the BCC, on rezoning applications. These are quasi-judicial in nature, and these hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts and closing arguments limited to the evidence in the record. And before making a decision, the planning board will consider the relevant testimony and the exhibits entered into evidence today. Each individual who wishes to address the planning board must complete a speaker request form and submit to the planning clerk at the front of the room. The forms are on the table in the back of the room, and you will not be allowed to speak until you receive a form. And please note, only those individuals who are present and give testimony today on the record will be able to speak before the subsequent hearing at the Board of County Commissioners meeting. No new evidence can be presented at the Board of County Commissioners meeting, so all testimony and evidence must be presented here today. The Planning Board will provide a recommendation for each rezoning request to the BCC, which will review testimony, documents, and exhibits, consider closing arguments, and make the final decision. All decisions by the BCC are final, and anyone who wishes to seek judicial review of their decision must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communication outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As we hear each case today, I'll ask that any board member who has been involved in any ex parte communication to please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent, substantial evidence of the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area that is required for mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. A, consistent with the comprehensive plan. That the proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 3 and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU map amendment transmitted for state agency, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, compatible with the surroundings. All the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. These uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing laws. D, appropriate spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences between those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated districts and adjoining lands. And E, appropriate with changed or changing conditions if the land uses or development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree in character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create sprawl. So at the beginning of each case, as long as there's no objections from the applicant, I'll allow staff to briefly present their maps and photographs of the property. Next, we'll hear from the applicant and anybody that they may wish to call forward. Then we'll hear from staff and anybody that they may wish to call forward. And then finally, we'll hear from members of the public who have turned in a speaker request form. Today, we have two cases to be heard. The first is the rezoning application, case number Z-2025-05, which requests rezoning of 220 East 9 Mile Road from commercial district, 25 dwelling units per acre, HDMU, high density mixed use district, 25 dwelling units per acre, and HCLI, heavy commercial and light industrial district, 25 dwelling units per acre, to commercial district, 25 dwelling units per acre, as requested by Jay Broughton, agent for Gulf Winds Credit Union, the owner. And members of the board, has there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And then please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all?
No to all.
No to all.
No to all?
No to all.
No to all.
No to all.
Alrighty. And do we have the representative for the applicant here today? And are you okay with staff presenting photographs and maps first? Okay, great. We'll go ahead and knock that out.
Good morning. Good morning, planning board members. My name is Horace Jones, the Director for Development Service Department of Assembly County. I will be presenting this case on this morning. For this morning, we have the location map, as you can see on the screen. We have the 500-foot radius zoning map. We have the future land use map. We have the wellhead protection map. We have the area map. You have the public notification map. The signage again for the rezoning map. There's a picture of the site that's in question. Again, there's another picture for the site that is in question with the parcels as well. You have across the street from the site in question. Another property looking east from the subject property. Public hearing sign posted on 9 Mile Road. We have looking north from the 9 Mile Road and commercial intersection. Looking east from subject property across 9 Mile Road. Looking south along the 9 Mile Road of the subject matter property. Public hearing sign posted on property along Hoseberry. A view of a portion of the property along Hoseberry. Another view of the property along Hoseberry Road. Looking west along Hoseberry Road. Looking east from the property along Hoseberry Road, looking south. And I believe that's the conclusion of all of the maps and the pictures.
All right, appreciate it, Horace. All right, Mr. Broughton, I'll get you up here now. And we'll go ahead and have you swear in as well and just state your full name and address for the record.
Yeah, good morning. Jay Broughton with Broughton and Associates, 314 Magnolia Avenue, Suite 115, Fairhope, Alabama.
Raise your right hand, sir.
No.
You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
And just a couple questions real quick.
Sure.
Get on the record here. Have you received a copy of the rezoning hearing package with findings of fact for today's case?
Yes.
And you understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
Yes.
All right. Floor is yours.
Okay. Like I said, I appreciate y'all's consideration on this. Obviously, the purpose of this rezoning is to create all like-zoned parcels so they can subdivide to build the new admin building there. It is in keeping with current development trends of the area. It's already commercial. It's a commercial use now, so it'll really just enable them to build a real state-of-the-art headquarters facility. I know there's some concern about one of the parcels on Hillstrand. That plan has been revised now to include a much bigger stormwater facility. And it's going to have walking trails all the way around it. So it's really going to promote a lot of the green space and natural features of the site without just completely, developing the whole thing. So if y'all have any questions, I'd be more than happy to answer them.
All right. Board, do y'all have any questions at this time for the applicant? No. All right. And you did get staff's findings, and were you in agreement with their findings that they had
Yes.
for today's case?
Yes.
Okay. Reed, did you have something, or did I make that up? Okay. All right. If we do have questions for you, we'll get you back up here.
Okay. Perfect. Thank you.
All right. Staff, I'll have you go ahead and make horse.
Yes, sir,
You
thank
will.
you. Thank you, Chairman Wilson. For today, we have this following rezoning case Z 2025-05, again, as stated, 220 East 9 Mile Road. We have several zoning categories on this property. We have the first is high-density mixed use with a density of 25 dwelling units per acre. Again, on the same parcel in question, we have heavy commercial, light industrial, and also we have a portion of the property as zone commercial, as you can see from the map when the map will come up. They all want to go to one zoning category, which is always good for everyone in the county, which is a consistent zoning category. So we have criterion A, consistent with the comprehensive plan. You can see the provisions that are referenced, CP Flu-1.31, Flu 1-51, and the other one. Now we have two future land use category on this site. You have the commercial flu as well as the mixed use urban. Both of those future land use categories, they are consistent with the zoning categories on the property that are currently, and even with the proposed. So the proposed amendment to commercial is consistent with the flu categories of commercial and mixed use urban as stated in CP Flu-1.31. The commercial future land use category allows for different type of retails and services as well as residential if part of a predominantly commercial development. Likewise, mixed use urban future land use category allows for an intense mix of residential and non-residential uses while promoting compatible infill development, and all of that is very, is what's going on in this area as far as the comprehensive plan. We have criteria B, consistent with the Land Development Code. We have the following sections that has to be found to be consistent. So I'm going directly to the findings for criterion B, and it says verbatim, commercial zoning may be established only within the mixed-use suburban, mixed-use urban, or commercial future land use category. The district is appropriate to provide transition between area zone or use as high-density mixed-use area zone or use as heavy commercial or industrial. Rezoning to commercial is subject to the same location criteria as any non-residential use proposed within the commercial district. So again, for criterion B, we found that there was consistency with the existing regulations of the Land Development Code. So now we have the criterion C, consistent with the surrounding areas. The findings is as following. For criterion C, I'm going to read it verbatim. The proposed amendment is compatible with the well-established general commercial uses, developments, and activities surrounding the subject parcel as stated by the applicant. We know the area is very commercial, highly predominant commercial corridor surrounding the subject parcel. Notably, the area that's in close proximity to these parcels contains a wide range of existing high-intensity general commercial use, including both intensive retail operations and heavy commercial with limited industrial-type activities. So again, criterion C was found to be consistent with existing regulations. Criterion D, appropriate if spot zoning. I'm going to read the findings. Given that the subject parcel is surrounded by a plethora of existing general commercial uses with conforming zoning designations, the proposed rezoning does not constitute spot zoning as defined and referenced in criterion D. The last criterion that we have to look at today is appropriate with change or changing conditions. Findings for criterion E. The land uses and development conditions in the area surrounding the subject property have changed and continue to evolve. General commercial businesses are being established throughout the vicinity. The proposed rezoning is appropriate and consistent with the ongoing transition occurring within this predominant commercial corridor. Importantly, the rezoning requests represent an expansion of an existing commercial operation located along an arterial roadway that already supports other intense commercial uses. As such, this request does not contribute to urban sprawl as defined by the Escambia County Land Development Code. According to the code, sprawl is defined refers to the haphazard pattern of dispersed and strip development in suburban and rural areas, particularly along highways. The pattern is characterized by low density automobile-dependent development with single or unrelated multiple uses, inefficient extension of public facilities and services, and lack of clear separation between urban and rural areas. So again, as stated previously in the same section, the proposed rezoning is consistent with the established commercial development pattern and does not meet the criteria for urban sprawl as defined by the county. So in my conclusion, it appears that each rezoning criteria has been met according to the terms of the Land Development Code as well as the comprehensive plan of Escambia County.
Thank you, Horace. Board members, are there any questions for staff at this time? All right, seeing none, we will move on to comments from the public for those who have signed up. And members of the public who wish to speak on this matter, please note that the planning board, we based our decision on the approval conditions and exceptions described in section 2-6.8 of the County Land Development Code. During our deliberations, the planning board will not consider statements of general support or opposition. Accordingly, please limit your testimony to the approval conditions and exceptions described in section 2-6.8. And please also note that only those individuals who are present and give testimony on the record today at this hearing before the planning board will be allowed to speak at the subsequent Board of County Commission meeting. So I've got two speakers signed up for this case. First is Laura Mitchell. If you'll please come forward and state your name and address for the record and be sworn in, and then we'll get your time started.
My name is Laura Mitchell, and I am a business on the corner of Holsbury and 9 Mile Road,
Address.
or 198 East 9 Mile Road.
Raise your right hand. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth.
I do. I would like to say I didn't come totally prepared to what I have been furnished with, and you have also, and the gentleman has discussed some of the information. I came here as a concerned citizen, not necessarily a business that I have on the corner of 9 Mile Road in Holsbury. I have been there for 35 and a half years, and I have seen the growth in that area. And trust me, I'd love doing insurance, and if it's commercial, I'd love to have my hand hold of it, but some things that doesn't happen. But to be honestly, and as honest I can about this, that road is not equipped to handle what you're asking to do here. You did a very poor job, in my opinion, of the last thing y'all approved over there, where that little horse place was, and you put in houses with no other outlet. There is an area right now that I am seeing. You put in those duplexes, 2-story, no parking when you got people who live there and they got 3 cars. You went ahead and put in another residential area across the street. Still, what are we doing? Their little retention pond went way over with the first big rain we had. That whole area is subject to flooding. I find it awful, awesome. Well, I'll save that for last. But I do not think the structure of what the use of that road is going to be. I cannot even get out of my office to turn right without the traffic backed up all the way to your first little commercial park you had on there. And that place is not dotted with commercial. That is all residential. I have another gripe about it is the fact that whenever we have these hurricanes come along and those people lose their power, I lose mine because I am on a residential feed. I've already had my little discussion with Gulf Power, so trust me, that's just the way it is. I have seen too many wrecks at that intersection. I get requests all the time to do I have a camera to see what happened at that intersection. And purposely, I don't have my cameras poised at that position so they can look at it because I would be inundated. We did have a death, and I therefore did offer the footage at that point in time. The infrastructure is not there. You got a school right down at the end of Holsbury. The cut-through traffic is ungodly there. I have a water main or something there. The ECU has replaced 2 to 3 times because those big trucks at that little dump area,
I'll let you wrap up real quick.
they have come and had to replace more than 3 times in the 35 years I've been there because the trucks are turning right and they're heavy duty. And they're destroying that road. That little 2-lane is not meant for heavy duty. I will be prepared for the next speech, I promise you.
Yes, ma'am. I appreciate it. Thank you so much.
Thank you.
Next speaker is Chris Kerb. If you'll please come forward and state your name and address for the record and be sworn in.
Chris Kerb, I live in Crescent Lake.
Raise your right hand. Do you solemnly swear or affirm testimony about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
What's your address, sir?
5999 Somerset Drive in Crescent Lake. Well, I'm not either for or against this one because it looks like the density is going to be the same. But this is the same issue that you got on Bellevue with the rezoning there. Your code design standards for a 100-year storm is not up to par. Your county allows archived rainfall data that DOT archived and says do not use for design. Therefore, you're not meeting a 100-year storm as specified in your code. Therefore, legally, when you claim an act of God, which is a legal term, force majeure, you got a losing lawsuit. Now, we have a pretty good active hurricane season coming up. A couple of weeks ago, we had 4 1,000-year storms in the United States in a period of a week. The data that y'all's using or allowing to be used by your design engineers, it only goes up to a 100-year storm. So the area of Holsbury, Sprague, and the few roads that run over to the Holsbury Pond that DOT expanded a couple years back. I think it was about 35, 40 homes that flooded in April 2014. There's a whole bunch over on Chandler. All this drainage goes over there. My recommendation to your engineer for the applicant is don't use the minimum design standards. Use your NOAA Atlas 14 and 15 if you're happen to do your design after 2026. Otherwise, you're going to end up in a lawsuit. Thank you.
Thank you, Chris. All right, board, is there any questions that anyone has for applicant or staff or any members of the public that spoke? And the applicant or staff need to add anything before we have discussion, or?
Yes, sir. Go ahead.
Yeah. Again, Jay Broughton, I don't know if I need to go through all this again, but all really great points that have been brought up. And look, they're pretty systemic. Doesn't matter whether you're in Pensacola or Baldwin County or farther into the Panhandle. Look, the impacts of traffic and growth and density and development, it's felt everywhere on roadways, utilities, stormwater facilities. So a couple of things that I've picked up on. I'm going to address the traffic first, and then we're going to talk about the stormwater. And I'll keep it pretty brief. As far as traffic goes, right now there's only a single access point, right, to the existing facility. Once this is developed, there will be 4 access points, with a new one being off of Allison, which is going to be dedicated strictly for employee usage, right? So what is happening is that we're actually distributing the flow of traffic more, instead of everybody coming into a single point and leaving from a single point. Now you got, I guess for your clients and your customers, you got 3 different entrances to choose from. The employees have got a designated entrance. So it'll distribute the traffic a little better than it is today. As far as stormwater goes, we design all of our stormwater facilities first and foremost to our best judgment. We look at not just what's published in the standards and the regulations, but we also look at current NOAA rainfall data, which they update that pretty regularly. So you actually get a real-time rainfall data for these different storm events. And I happen to really like my license, so I'm going to make sure everything's designed such that we're not going to get ourselves in trouble. And to make sure that we're doing right by the community and protecting upstream and downstream infrastructure. So so we will, obviously, when it comes time to, to get this permitted, everything's going to be designed according to the current standards and regulations, but also to sound engineering judgment, cognizant of what's going on with the times, with traffic and development and density increasing and all that. So that's the only thoughts I had. And if y'all have any follow-up questions, I'd be happy to answer them.
All right, any questions from the board?
Do you have any imagery of the proposed development of what the final site layout would look like?
We do. I'm not prepared to have it. I don't have it right now, but we do have some imagery. I'm sure we'd be happy to share.
And this is just a improvement to the current building there, or completely raise and
It's expanding on.
Okay.
It's expanding the existing facility there.
Okay. Thank you.
Yeah.
And if I may, they are definitely engaged already currently with the site plan review process. We had a good pre-application. We have all of the drawings, all of the plans. They are already currently based in our pre-app and initial review. And everything that he has indicated, staff will make sure that they adhere to those standards. And even if there's an intention to go above, they will, because we do know our engineering department, they are quite aware of all of the issues. So working with the engineer, and we're going to make sure that when this comes to the point, that there is known that it will not create additional impacts to the area.
All right, go ahead.
Thank you.
Anything else?
Just making note that we also understand up here that our purview is not due to one particular development, it's simply the zoning change at hand.
Yes.
Correct. All right.
You're absolutely correct.
All right, if there's, thank you very much.
All right, thank y'all.
There's nothing else at this time or questions from the board. I will entertain a motion if someone would like to make one.
I make a motion based on staff findings and the applicant's agreement with those findings that we approve case Z 2025-05.
Second.
Okay, we got a motion to second. Any discussion on the motion? Seeing none, all those in favor, please signify by raising your right hand. All those opposed, motion carries. Thank you very much. And we'll move on to the next rezoning application for consideration today is case number Z-2025-06, which is requesting rezoning of 1980 West 10 Mile Road from LDMU Low Density Mixed Use District, 7 dwelling units per acre, and MDR Medium Density Residential District, 10 dwelling units per acre, to Commercial District, 25 dwelling units per acre, as requested by Allie Palmer and Hadley Peterson, agents for Flatrena Self-Storage, IV DST Manager, LLC, trustee for FAM Shelf Storage, for 111 DST Trust owner. Members of the board, have there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, or witnesses, with fellow planning board members or anyone from the general public prior to this hearing? Did you visit the subject property? And please also disclose if you're a relative, business associate of the applicant or the applicant's agents. Oh. I'll start.
No. No to all.
No to all.
No to all. No to all?
No to all.
No to all.
Alrighty. And then Ms. Palmer, are we good with staff presenting photographs first? Okay. All right. We'll go ahead and have you do that.
Good morning, Board. Caleb McCarty, ASCP Certified Planner and Planning Manager for the county. Here for case Z 2025-06. This is our location map showing the subject property along 10 Mile. Here's our 500-foot radius zoning map showing the southern half of the property is LDMU, low density mixed use, and the northern piece is MDR, medium density residential. The future land use of the property is mixed use suburban. This is showing the 20 and 7-year wellhead in the area, which factors into our development standards. This is a subdivision map that we included with our findings, showing the subdivisions in the surrounding area. Here's an aerial photograph that shows the current state of the property. This is our notice of public hearing sign that we placed at the front of the property along 10 Mile. This is looking north onto the site. There is a current storage facility that's been there for some time in operation. This is looking east along West 10 Mile Road there. This is looking west along West 10 Mile Road. And this is looking south across West 10 Mile Road. That concludes our maps and photos for this case.
All right, I appreciate it.
Thank you.
And then Ms. Palmer, we'll get you up here now and have you please state your full name and address for the record and go ahead and be sworn in.
Good morning. Thank you so much. Alessandria Palmer. I am with Kimley Horn and Associates.
Just a little bit there, just a little.
Too loud.
Now step forward a little bit. There you go.
There we go. Now, don't move. No.
Did I step on the X? Okay. Thank you. 2619 Centennial Boulevard, Tallahassee, Florida. And I'm here representing the Storage Rentals of America rezoning request.
Raise your right hand. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Alrighty. Did you receive a copy of the rezoning hearing package with findings of fact?
I did.
Okay, and do you understand you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
I do.
All right, you may proceed.
Thank you. So we have a brief presentation. I'll try to run through it. A lot of this information you've already seen in your package, but we did want to put it on record for you today. So as staff mentioned, the property is located at 1980 West 10 Mile Road. The property size is approximately just under 7 acres. Today, the site is developed. It is urbanized. It holds many warehouse and self-storage uses. There's 8 existing buildings on the property with a total of about 35,000 square feet. All the buildings are 1 story. And there is also, as you can probably see in the aerial, a good bit of outdoor storage that's existing on the property today, uncovered. Next slide. Also, as staff already mentioned, the future land use of the property is mixed-use suburban. We are not proposing any changes to the future land use. We are only requesting a change to the existing zoning district. As mentioned today, the zoning district is lower density mixed use and medium density residential. So it is already a split zoning condition, which we are trying to resolve with the request today with the proposed rezoning of commercial, which we find is more suitable for the existing use of the property. So we'll run through the rezoning approval conditions here in the following slides. First, with consistency with comprehensive plan, as mentioned, the future land use is mixed-use suburban, which encourages residential, commercial, and institutional uses. We are proposing the continuance of the existing use, which is mini warehouse and storage, and we find that that is in support of the mixed-use suburban future land use designation. The rezoning aligns with the mixed-use suburban future land use goals by promoting neighborhood-serving development. We know that there are many residents in the area that utilize this property and the warehouse use, self-storage use, and we see that continuing, and we'll talk about that here in just a minute. We also find that this is consistent with the infill development policies of the comprehensive plan, specifically policy in future land use 1.5.1. And we also find that the proposed rezoning is consistent with the comprehensive plan because we are not proposing anything that would be more intense on the county's level of service, including traffic, utilities, and public safety. Self-storage use, as you probably could imagine, is a very low impact use. There is not a lot of traffic that enters the site, and it has very low impact on the county's utilities and emergency services. Next slide. Thank you. Consistency with the zoning district provisions. As mentioned, we are proposing a commercial zoning district. The proposed use is consistent is permitted within the commercial zoning district amongst a wide range of neighborhood serving commercial uses. The site itself as it exists is also consistent with all of the development regulations for the commercial zoning district. And the applicant will, of course, ensure that any future modifications to the site would also be consistent with those regulations. Compatibility with surroundings. It's important to note that, again, this is an existing self-storage use. The use has been there since 1997 and has been operating consistently through that time frame. It has never closed. The self-storage, again, is a low-impact transitional use, compatible with, we feel, with the residential because it provides somewhat of a buffer between the heavier industrial uses and the railroad to the east. And so it essentially provides a bit of a transition zone between those uses and the residential to the west. Some of the things that the applicant plans to do as they begin improving the property in the future when they come in with a site plan is providing a new fence and a landscape buffer between the residential and the subject property, which will help with those compatibility enhancements. I believe staff already went over the surrounding uses, so I'll skip this slide. And then this is just a very high-level concept buffer plan that essentially demonstrates how the applicant may propose to show that buffer when they come in for site plan approval. But essentially, it would run along the entire two boundaries in which they are adjacent to the single-family residential use. And again, that would include landscape and a fence. It's also important to note that as they modify the outdoor storage areas of the site, that anything that is uncovered in nature would be removed from the perimeter of the site as well in the future, any future redevelopment or modification to the site. Appropriative spot zoning. We feel that the rezoning is appropriate, reflecting a logical, context-sensitive land use transition. Again, adjacent parcels to the east include that heavy commercial and light industrial zoning. And so this proposed rezoning would really enable that transition zone from the industrial to the east to the residential to the west. Appropriate with changed or changing conditions. So, as mentioned earlier, we do feel that there has been an economic and demographic shift in the area that has increased the demand for self-storage. We know it's being utilized today to its capacity. However, we feel that this type of use will become more and more demand in that particular area and in the county overall due to an aging population and, of course, because of just general population growth in the county. The owner does plan to modernize the facility. They are going to be creating more temperature-controlled indoor storage, and they're going to be, again, as mentioned, essentially modifying the outdoor storage areas so that they are better screened and essentially beautifying the property so it looks a little bit better for the neighboring residential. If the rezoning is adopted, the applicant will submit the site plan amendment to address many of these compatibility and enhancement issues. And with that, that concludes my presentation. I'm happy to answer any questions. I also have a member of the ownership team who is here with me today, and he is also available for questions.
All right. Thank you. Any questions from the board at this time? No? All right. Staff will have you run through your presentation.
Excellent. Thank you again, Board. As a reminder, this request is to be rezoned. Current zoning LDMU, low density mixed use, in MDR, medium density residential. The rezoning request is to take the property to commercial entirely. I believe the applicant gave a good presentation based upon the criteria of the Land Development Code. We did find that the rezoning request did meet all the criteria. There is some critical information from staff perspective that would support the rezoning, and we found that it did align with the comprehensive plan in the Land Development Code, and I'll hit on those key points here. Concerning criterion A, consistent with the comprehensive plan, we found that the proposed amendment is comprehensive with the intent and purpose of future land use category, mixed-use suburban. The mixed-use suburban does allow for residential development and different types of retail sales and services. In accordance with our comprehensive future land use criteria 1.5.1, the maximum densities and intensities are encouraged in underutilized properties in the mixed-use suburban category. Furthermore, as in the future land use 2.1.2, it promotes compact residential development by allowing rezonings to higher densities in the future land use category. We also found that the proposed amendment is consistent with Comprehensive Plan Future Land Use 1.1.2 by correcting the non-conforming uses of the property through the requested rezoning to commercial. The policy of the Comprehensive Plan states that the Land Development Code shall contain detailed and specific provisions to implement the goals and objectives and policies of the plan. Additionally, it provides that such regulations shall include provisions for the correction of non-conforming uses and structures, supporting the broader planning goal of transitioning such non-uses into conformity with adopted regulations. From Exhibit A, as we provided, our research found that, per the County Development Archives, it appears that the existing legal non-conforming use, as determined by the current zoning, not allowing for the existing use, was established sometime in 1997 with approval given for the development of the site for a business known as Pop's Attic Storage Facility. It must be noted that at that time, the proposed zoning regulations and provisions for certain areas within the Escambia County were not clearly established as a rule of law, as the zoning regulations and associated provisions applicable to certain areas within Escambia County were not clearly defined or fully enforced as the prevailing rule of law. It appears that this type of business at the subject site has continued to operate without interruption. As such, the long-standing operation of the business qualifies it to be considered a legal non-conforming use as governed by the current provisions of the Land Development Code and the Comprehensive Plan. Concerning criterion B, if it is consistent with the Land Development Code, we found that the proposed amendment to rezone to commercial is consistent with the Land Development Code. The intent of the commercial zoning district is to allow for more diverse and intense commercial uses than the neighborhood commercial uses allowed in the mixed-use district. All commercial zoning uses are limited to the confines of a building and are not allowed to produce undesirable effects on the surrounding property. The property to the west is a platted residential subdivision that is zoned LDMU and MDR. The proposed rezoning to commercial is an appropriate transition between the LDMU and MDR property to the west and the HCLI heavy commercial light industrial property to the east. Now, in section 1-2.3, 1A of the Land Development Code allows for legal non-conforming uses to be converted to or replaced with a conforming use. Based on the documentation submitted by the applicant in support of the rezoning request, the proposed district would allow for the existing use if the request is approved. The applicant has also demonstrated actions toward compliance with all current regulations, including applicable site and building requirements, as well as the submission of all required documents necessary for review. Taken together, this indicates a proactive and strategic planning effort by the applicant to bring the use into full compliance with current regulatory standards. This intent aligns with the overarching goals of the comprehensive plan and the Land Development Code provisions and supports the rationale for favorable consideration of the rezoning request. As note, the previous zoning designation of VM2 of the southern portion of the property would allow for many storage facilities. Additionally, in a memo dated July 22nd, 2025, our TTO provided some comments related to the request, and they have no capacity concerns related to West 10 Mile Road. Concerning criterion C, if the proposal is compatible with the surrounding uses, the proposed amendment is compatible with the surrounding properties in the area. The existing use as a storage facility is considered a non-conforming use within the current LDMU and MDR zoning districts. Per review of aerial photos and county records, it appears the current use as a storage facility may precede any zoning requirements as assigned by the county. A historic site plan for initial approval of the storage facility was issued by the county in 1996, with subsequent county approval of the northern storage buildings in 1999. We provided attachment and as Exhibit A, Pops Attic 1996, and Exhibit B, Pops Attic Edition 1999, and those available for viewing if needed. The surrounding uses vary greatly. Within the 500-foot radius, all properties are within the MDR, LDMU, commercial, and HCLI zoning districts that consist of single-family dwellings or commercial and industrial uses on individual lots. The abutting MDR zone property to the west is an 85-lot single-family dwelling subdivision containing newly constructed homes, which is Allison Acres, and totaling approximately 18 acres that was platted in October 2022. The property to the south along West 10 Mile varies from commercial to MDR zoning and consists of individual single-family dwellings and mobile homes on the individual lots. To the east, heavy commercial and light industrial uses are found in the subject property's western property line, lies along the railroad right-of-way there. The requested rezoning is corrective in nature, and the outdoor storage and outdoor uses are not found as a permitted use of the requested commercial zoning district. Therefore, the owner applicant must take corrective action for any nonconforming uses prior to any redevelopment authorizations. Additional requirements of the Land Development Code that establish and maintain compatibility with the surrounding uses include substantial buffering and fencing that will be required in the redevelopment of the property. We also found that the subject property is in accordance with the location criteria of the commercial zoning district. The subject property is along a major collector street of West 10 Mile Road and less than a quarter mile from South Highway 29. Criterion D, if the request is appropriate if spot zoning. By definition, the proposed amendment to commercial would be considered spot zoning as there are no abutting commercial zone properties. However, the existing use as a storage facility is long established on the property, and the proposed rezoning to commercial acts as a transition between the MDR and LDMU zoning districts to the west and the HCLI zoning districts to the east. Then finally, criterion E, appropriate with change or changing conditions. The land uses or redevelopment or development conditions within the area surrounding properties have changed. The subdivision to the west, Allison Acres, again is an 85-lot single-family residential subdivision that was recently approved by the county, and therefore the rezoning request would allow commercial uses that support the surrounding residential and commercial uses of the area. The development within the area has remained a mix of residential, commercial, and industrial uses, and with the request for commercial, the potential uses, density, and intensities allowed by that district would be compatible with the existing surrounding development patterns. The proposed amendment would not create or contribute to urban sprawl when assign appropriate zoning to the property based on the established historic use, requiring buffering, fencing on the adjacent residential uses that is otherwise not currently in place. that's our findings for this case.
All right, thank you very much. Are there any questions for staff from the board? All right, seeing none, we do have 3 speakers from the public that have signed up. We'll start with John Schuman. If you'll please come forward, state your name and address for the record and be sworn in.
My name is John Schuman. I live at 1919 West 10 Mile Road.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You're good to go.
Okay.
Yes, sir.
I live directly across the street from the, not directly, but catty corner across the street from the storage building. I've been there ever since the original storage building has been installed. What I would like to know is why the storage building facility is now going to be commercial when on West 10 Mile Road there's no commercial zoning. And why is it changing from limited LMDU to commercial? Also have concern about traffic, if it's going to be expanded or what have you. There's only one access road, which to 29 is 10 Mile Road. And in the mornings, the traffic's from the railroad track to Stefani. And you can't even get out your driveway. Also, recently the storage facility part, you have up front the undeveloped area. They came in and they did drill testing, perk testing. What I want to know is, what are they building? What are they changing? You know, it's been there since 1997, no problem. But why the commercial? Why can't it maintain residential? You have, like you said, 88 new homes adjacent to it. Just completed some homes right next to the property line where the storage facility begins. You know, my understanding is it shouldn't be commercial, because then you can have anything and everything. And the only other business on 10 Mile Road, West 10 Mile Road, is Barbara Judah Bait Shop, the storage facility, and the nursing home that's next to my property. So, you know, I'm against the change to commercial. That's all I have to say.
Thank you, Mr. Schuman.
Okay.
All right, next we have Jody Schuman Davis. If you'll please come forward and state your name and address for the record and be sworn in.
I'm Jody Schuman Davis. I'm 5410 Garden Brook Boulevard, Milton, Florida.
Raise your right hand, please. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes. I wasn't prepared to speak, but since I heard that you have to speak to be in the meeting, so basically what my dad just said, this property right like cat a corner across is my family. I will be inheriting it. I don't understand why. Like he said, going to go from this to commercial. I look right outside. It's a beautiful piece of property. It's been in my family since the 1800s. I have the land grant and everything. The property that they're changing up, that used to be a historical family-owned business, family-owned property also. I'm okay with the subdivision going in. It's beautiful. It's HOAs, you know, but I bet they have no clue that right behind them will be a commercial business. So I just against it, and like you said, traffic, especially when school's in, coming is just lined up. They're not even able to get out of their driveway. So I'm very against it, because like I said, once you make it commercial, we don't know what's going to go in, even though they say I don't want to look out and see a 2-story, a 3-story commercial storage facility. This is all residential around us, and little bitty, like a small house of nursing home, only holds 10 beds and stuff. So I'm against it, and thank you for my time.
Thank you. All right, Chris Kerb, you're up next.
State your name, and briefs this one.
Chris Kerb. I'm with Flood Defenders. Matter of fact, when Pop's Attic was approved in 1996, I reviewed the stormwater management plan for that project, and it's in the 8 Mile Creek Basin, and I think the county's, I don't know how many millions of dollars the county spent on drainage in that basin. But the design standards back then were a 25-year design storm. But back on the act of God, the legal term, 100-year storm, I think I remember, I'm a little vague there, but I think I asked the engineer to design to a 100-year storm back then because of the drainage issues in the 8 Mile Creek Basin. This one actually increases density. So if you increase the density, you increase impervious area, you increase stormwater runoff, and you increase your cumulative impact to downgradient properties. That's something that the HBA brought up, that, oh, we're not having any problems using this old 1979 rainfall data in our developments. Maybe you're not. It's all about the downgraded impacts to your watershed, your cumulative impacts. Let me give you an cumulative impact here. Was it 6.89 acres? If you look up NOAA Atlas 14 rainfall data versus the 13.44 inches that the county allows to be used right now for stormwater design, versus 16.2, which is what NOAA says for this site is located. The difference is 2.76 inches. Multiply that over 6.89 acres and you get about 10,000 cubic feet. That's a lot of water that's not being accommodated in your stormwater designs. And if you multiply that by however many sites in your watershed, no wonder our creeks are flooding. No wonder our homes are flooding. No wonder we're shelling out millions of dollars fixing these drainage projects, drainage problems. When I mentioned lawsuit earlier, it's just a matter of time. And I really hate to be on the other side of the fence suing the public when a resident gets flooded out, because we decided to use archived rainfall data. Thank you.
Thanks, Chris. All right, board, any further questions for the applicant, staff, or any of the speakers?
I was going to ask staff, when you mentioned that the with this zoning, they have to come up and do some additional requirements to what it appeared was make it aesthetically pleasing. Does that also take into account, again, what we're talking about is a lot of this is drainage and water. So the additional 25 units per acres and the density, you're taking that in consideration, or are you doing that per development submitted to you? In other words, when you're looking at this, you're only going to address it when the proposal or the plan is submitted to you according to what they're proposing, I'm assuming. But in your estimate of changing this zoning, does that consideration come in under review as far as stormwater? And
Yeah, absolutely. So the applicant has been engaged with our development review team with the county, and that essentially would be reviewed by them. I would note that, although we can't conditionally rezone the property, that engagement and the applicant understands that the existing site is non-conforming. And that's the key, and that was the key in our findings, in that this was issued a development order for a storage facility years ago, prior to all indications, before zoning was even adopted for the property. Well, we came along as the county, and as we've seen in a lot of these rezoning cases, we have a rezoning, or the zoning assigned to the property didn't even allow it in the first place. So we see that the applicant is taking a corrective approach and assigning an appropriate rezoning when the actions actually may have fell on us. So, and it's great. We wish things would go more like this, because also the applicant understands that all the outdoor stores that you see on that site, in addition to the brand-new subdivision beside it, requires some extensive buffering, and all that stuff is going away. So that the assignment of the commercial zoning district, it essentially would rectify, and is really a prime example on how these things can be beneficial, whether it's for the applicant or for the county provisions when our land development code and comprehensive plan. As far as the stormwater goes, yes, there are some improvements that are going to have to be done in coordination with our county staff to make sure it's in full compliance. It may not be in compliance with today, just as the zoning's not in compliance. It may not be in compliance, but now's the opportunity for rectification of not only the zoning, but potential site work that would need to be done to bring it into current land development stormwater requirements. Yeah.
And if I may,
Yes, sir.
if I add to this, one thing that I am learning from the county engineering department is that they do look at, with our new standards, they do look at off-site impacts. They do look at all the surrounding areas so that it can enhance it and not make it worse. That's one thing that I am learning more and more. And I got 4 more years to learn.
So-
That they do look at off-site impacts when it comes to drainage and all of those issues.
Right, so, I mean, we're caught in this happens too many times. We didn't have zoning, now we have to figure it out and make it look pretty, and they're helping by making this look conforming. To the people in opposition, it makes sense, because we're told not to look at the development. We're told to look at the zoning change. And to their point, this will be commercial. Well, I guess my question to the applicant at this point in time is not only, I have 2 things. First, for the applicant, what is the impacted or theoretical future increase in units there? How much more? But and then 2, my question, I guess, for county is 2014, the spring rains that absolutely flooded everybody?
Yeah, that was.
Okay. Did that alter, I mean, everyone's, and I know Chris is probably frothing at the mouth over there, but I mean, did that not alter our overall assumption of engineering?
Yes, Mr. Powell, you're absolutely correct. That was an abnormal event anyway. It was horrendous. And after that, with my limited understanding, that they really had a SWAT stormwater committee, and they looked at all of that, and they did some substantial changes that we're dealing with, that we yet making changes to that. So 2014
Yeah. It's
was
just
the
like,
catalyst for
it
change.
seems like we have a 100-year event every 2 to 3 years.
Yeah.
So I guess it bears, certainly further investigation in that.
Yeah.
But I would ask the applicant, for the benefit of the folks that live across who have, again, to their point, they lived there happily with this nice Pops attic. They're not opposed to necessarily the business, but we're not supposed to really look at that.
Right.
So I'd be interested to hear what the applicant has to say to, resolve any fears and/or,
And if I may,
it's
Mr.
a little unusual, obviously, but. go
Mr.
ahead.
Powell, if I may, before you have commentary, you're absolutely correct. We're not supposed to. Even if the property is zoned commercial, all of the high standards for any development will yet have to come into play. All of the higher standards for any development. Right now, if that use stay in, they can continue to keep it as is. But when they change the rezoning, we don't look at this use specifically, but going to that zoning category, all of the high and the best standards will be, which will make which has the tendency to make the whole area better and more compatible.
Do you want me to?
State your name.
Bo Raish, R-A-I-C-H.
R-I-S-C-H, address.
15290 96 Lane North, West Palm Beach, Florida, 33412.
Raise your hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do. Thank you all. Bo Raish, I'm with Storage Rentals of America. I run the development team there. I'm VP of Development. We are a vertically integrated self-storage company. We're nationwide. We own about 700 stores. That's all we do is self-storage. I don't, and we own them in funds that hold them for, pretty long term. We've actually never sold anything that we've ever bought of the 700 stores. So this fund has at least a 10-year life, which will probably be extended. Once these things are built and leased and operating, you don't tend to just go tear them down and build something else. I mean, absent some compelling reason to do so, which would have to be put in front of you and be a compatible use of, with your code. So, as far as our plans, it's, and I know you're not supposed to look at the development, we're just looking at the zoning. My intention here is to build just probably a 30 to 40,000 square foot single story storage facility, and then some covered RV parking, and then try to screen the whole property in. I mean, that's kind of, we haven't gotten into that. I know there's going to be a lot of stormwater improvements that need to happen. I need to get topo surveys. I need to get perk tests, geotech, all that stuff. Before, I didn't want to go spend, $200 grand on, engineering and studies before I even knew if I had the zoning. So that's why I don't have a, fully baked site plan to show you. But, that's our intent. And regardless, if we don't get it, at least we've rezoned the property and now it's a conforming use. So, which is a benefit to us. So that's what, that's what we're here today for. But as far as just, to reassure everyone, I'm not trying to do a bait and switch here and build a, used car lot or something here, whatever else would be compatible with commercial. This is going to be storage. It's going to be as low impact as possible. We do this all over the country. I've got, 20 projects going on at any given time. If I tried to fight the neighbors on every one of them, I'd, probably pull my hair out. So, we try to go in and build something that's compatible. I know I can't keep everybody happy, but, that's the goal here is just to, a beautification. I mean, I know we got a lot of outdoors. Last time I was on the property, I'm walking through there and, some guy's taking a shower behind his RV and asked me if I have any soap. I'm like, we don't want that. I don't want that for my customers, so, there are a lot of nice, I look at sort of the character of what's there. There's a lot of nice RVs there, people, I'm not providing a public service, but, for people that want to store their RVs, I'd like to keep providing that service, but we'll do so in a, we'll provide covered areas that are screened off from the thing. But we'll, and on that front, we'll be back in front of you with a full site plan for, for your consideration and approval. So, we can kind of deal with that then. But that's sort of what our intent is here, if that answers your question. Yep.
Thanks.
Why don't you do that?
Allie Palmer, again, Kimley Horn. From a technical perspective, I just wanted to address some of your questions. And so Kimley Horn is also, I am in the community planning practice, but Kimley Horn will also be handling the civil engineering and transportation engineering for the site development. And I just wanted to put on the record that we obviously will be looking at the county standards as well as the more stringent state standards as well. And so that will both be considered as we are putting the plans together to propose to the county for approval and permitting. Oh, and I did want to just add, and we will be getting with the adjacent property owner that's here today, but just for the record, as far as traffic is concerned, there is some benefit to the storage use remaining on the property because, as we know, storage use, AM and PM peak hour trips are completely at opposite times of the traffic that's probably coming on to 10 Mile from all the residences going to and from work during the business day. And so we're hoping that this will actually have very minimal, if any, impact to that traffic that's going to be on 10 Mile. But we'll be performing that traffic analysis, of course, once we come in with the proposed increase in square footage. Thank you.
Thank you. Any further questions from the board? All right. Seeing none, I'll entertain a motion if someone would like to make one.
I'd like to make a motion based on staff's findings for Z 2025-06 for approval.
Second.
All right, we've got a motion and a second. Any discussion on the motion? All right, seeing none, all those in favor, please signify by raising your right hand. All those opposed, motion carries. All right, that was the last rezoning case we had for the rezoning meeting, so we will adjourn the rezoning meeting and go into our regular planning board meeting. And so the meeting of the Escambia County Planning Board for August 5th is hereby called to order with 6 voting members present. We do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement. We have a motion.
So moved.
Second.
Motion is second. All those in favor, please raise your right hand. All those opposed, motion carries. Planning Board meeting minutes for July 1st, 2025 have been provided to the board members. Do I have a motion to accept?
So moved.
Do I have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries. Planning Board hearing package for August 5th, 2025 has been provided to the board members. I'll entertain a motion to accept the Planning Board hearing package and legal advertisement into evidence. Do I have a motion?
Motion to approve it.
All right, do I have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries. All right, we have one public hearing today, a public hearing to review and consider conformance of the Myrtle Grove redevelopment plan that the board review and recommend to the Board of County Commissioners for adoption of the Myrtle Grove redevelopment plan. So we'll turn it over to staff for presentation.
Good morning, Chair and Board. My name is Max Rogers. I'm a Development Program Manager with the Escambia County Community Redevelopment Agency. On February 20th, 2025, the Board of County Commissioners approved Resolution 2025-21, which was a finding that the proposed Myrtle Grove redevelopment area was a blighted area with a shortage of affordable housing for low and moderate income homes. All right. So the Myrtle Grove redevelopment area is 1,529.73 acres and consists of 3,746 parcels. Of that, of note is the Myrtle Grove redevelopment area is 82.3% residential. The Myrtle Grove redevelopment area will be the 10th CRA for the Escambia County CRA. It's adjacent to Brownsville. It's just west of it and borders it on New Warrington Spur, and it's north of the Warrington CRA. Its boundary is Mobile Highway to the east, West Fairfield to the north and west, as well as Jackson Street until you get to 57th Street, of which it goes above the Twin Pines neighborhood at the parcel level. Next slide, please. All right, the planning process, we had had input from the public at 3 public meetings, 2 in April and a final meeting on May 22nd to present the concept and receive input and then present the final draft at the West Coast Senior Center. Next slide. So we asked the question, is Myrtle Grove, is it blighted? We did a housing condition windshield survey as well as commercial blight survey. Took a look at the demographics and as well as crime. So Myrtle Grove's housing condition, most of it is fair, with 68.6% in the fair condition. Although they are older homes, they technically meet the fair qualification. However, 19.1% are in the worse, the poor or worse condition. All right, here's a couple images of the blighted commercial property, of which Myrtle Grove has some. So there's room for improvement that we would hope to improve through our redevelopment programs. Regarding demographics, Myrtle Grove has a substantially lower average household income, median household income, and per capita income, approximately between 26 and 29% less than the Escambia County average. It is interesting to note that the households below poverty level is actually, there's less of those in Myrtle Grove than there is at the county level. But that is attributed to that there's a higher percentage of what we call the ALICE households, which are asset limited, income constrained, and employed. And those are people that would be considered more the working poor that don't meet the federal poverty level standards, but they have trouble making ends meet. Other demographic data, including education, the amount of households with one car or less, support that the area is a low-income area in need of redevelopment and investment from the county. Next slide. Crime is higher in Myrtle Grove than it is in the rest of, in comparison for the rest of the county, in the areas of rape, robbery, larceny, burglary, and motor vehicle theft. Surprisingly, it has less aggravated assault and less murder than the rest of the county as a whole, but the data shows that the crime is higher in Myrtle Grove. So the question is Myrtle Grove blighted with 20% of the homes in poor and worse condition, commercial blight with demographics that with less income than the county average and a higher percentage of ALICE households, and in most categories crime is higher in Myrtle Grove and trending higher. So the data supports that Myrtle Grove is a blighted area. I reviewed the tools to address the blight with the public, and it's included in the plan. Investing in infrastructure is a very important thing that we can do. Improving safety, supporting public-private partnerships, as an example, our grant programs. Also providing home repair assistance to the low-income people who cannot afford to fix up their properties. Beautification and neighborhood cleanups. An overlay zoning district is an opportunity to promote quality commercial development, and is an opportunity as well to exclude new mobile homes and trailer parks. And having CRA staff for redevelopment is an opportunity to turn the area around. Next slide. So just real quickly, the objectives and strategies. This is where we got a lot of input from the public. These are very similar to our other CRA districts. We want to improve the appearance. We want citizen and business involvement. We want robust code compliance, investing in community facilities and programs, reducing congestion for all users, improving infrastructure, maintaining our infrastructure and our beautifications, reinvestment into the community, increasing security, and upholding the zoning and land use for the area. We also have area-wide strategies, which are just a slightly into a little more detail than the objectives. We want to make roadway improvements. We have code enforcement, crime reduction, improve stormwater drainage, provide housing across a wide spectrum, increasing neighborhood pride and citizen involvement, expanding the sewer network, and preserving commercial zoning on arterial roads and considering an overlay zoning district. For neighborhood strategies, we received input about stormwater flooding, adding sidewalks, extending the sewer, adding street lights, traffic calming, beautification, improving the fire station, which now has funding and is moving forward, and potentially redeveloping the old YMCA site at the corner of 57th and Lillian Highway. For commercial strategies, we have business quarter improvements such as gateway signs, landscaping, and removing blight. As an example, we provided the block at New Warrenton Spur, Lillington Highway, and North New Warrenton Road, which is a pretty good example of blight if you're familiar. For commercial strategies also would be to implement the Reimagine Jackson Street 2023 plan for streetscape improvements. Jackson Street in particular is important for the county to improve, is that it is a county road as opposed to Fairfield and Lillian Highway, which are state roads, which is a little bit more difficult to implement the beautification, but it is possible. We also have a list of capital improvements. I won't go through all of that, but we do have a robust list of sidewalk projects, stormwater drainage, which includes all of the SWAT projects that you mentioned. Mr. Pyle from the 2014 plan about everything that was identified and that flooded in 2014 became a SWAT project. So all those projects, in addition to others mentioned by the public, are included. We have beautification projects and park improvements. We also have sewer expansion projects. That one's going to be a little bit more vague as we get with ECOA into the future. This being a 30-year plan, we're just leaving it open to that we support sewer expansion. We also have the new fire station, possibly a new library at the old YMCA site as an idea, and speed bumps and traffic calming in the neighborhoods. Finally, as I'm wrapping up here, is the end parts of the plan are the plan implementation as required under Florida statutes that we mentioned, the implementation partners, which are the commercial reinvestment partners, housing partners, the capital improvement projects we're going to implement, and development controls. We also have financing mechanisms that could be CDBG, local option sales tax, private investment, the state and housing programs, as well as tax increment financing. A neighborhood impact analysis is required under Chapter 163, just to demonstrate that if this plan will have any negative impact on the neighborhood. We do not propose any relocation, so there's no issue there. Traffic circulation would be improved by the capital improvement projects for all modes. We intend to improve environmental quality with sewer conversion projects and ecological stormwater projects. We're going to support community and facility services, no impacts to schools, and we intend to improve the physical and social quality of the neighborhood, as well as coordinating with the sheriff's office. The plan has 4 appendices, which are the Myrtle Grove redevelopment area maps, the legal description, the public workshops, and selections from the Escambia County Comprehensive Plan. The comprehensive plan, I reference Chapter 7, the future land use element, the goals of future development pattern, development and public service. Chapter 8, the mobility element, including transportation. Chapter 9, housing element, with the goal of provision of housing. Chapter 10, infrastructure with wastewater, stormwater management, and potable water. And the recreation and open space element to increase recreation opportunities. So with that was a brief overview of what the plan is about and what the planning process was. If you have any questions.
Any questions from the board?
So I take this as the CRA is kind of a financial vehicle for these improvements, kind of the gate we have to go through in order to implement a lot of these. And then I would ask my associate to the right of me, in your estimation, how did the CRA help the Warrington?
I mean, that's better asked for actually the program head right there, actually, than anything else. I mean,
sure.
He can go, and then I can give my thoughts on
Sure thing.
every bit of this.
Yeah, so to implement the desires of the board by adopting the findings of necessity in February necessitated the creation of this plan and the TIF ordinance, which is in the backup. So by bringing this to the planning board with a favorable recommendation, this will go to the Board of County Commissioners on September 4th for final approval as a public hearing as well, which will adopt the redevelopment plan as well as put the TIF ordinance into place. So starting in next year, the TIF will start accruing slowly, and then we can start with small projects and then build it up further. Warrington is one of my districts, and that's been one of our economically most successful TIFs in that the area has grown from the base year. There's a lot of projects that we've done to improve the area. Obviously, it is a public-private partnership that the CRA can't fix it all, but through our grant programs, investing in infrastructure, working with the Sheriff's Office to reduce crime, we help to bring in new investment and redevelopment of the area. So we hope that Myrtle Grove will be similar to our other CRAs, in particular like Warrington.
If you could give a broad history lesson on these CRAs. This would be the 10th. What was the first and when was it implemented?
Sure. That was Warrenton, actually. It was 1995. So Escambia County had 5 original CRAs in the late 90s and early 2000s.
So the first 5 were all at once?
Right in the same area, right around the same time. So
Okay.
very first was Warrenton. Actually, if you go to that screen, so
Yeah.
it's the most southern one. So you have Warrenton, Barrancas, Brownsville, Englewood, and Palafox. Warrenton was first in 1995. Brownsville was second in 1997. Englewood and Palafox were, I believe, 2000, and Barrancas, I believe, was 2002. So for quite a while, those were the original CRAs. Since then, I believe it was 2010, Cantonment was created, but the finding of necessity was approved in 2010, but the plan wasn't created until late 2013 or 2014. And then we had Ensley and Oakfield created at the same time in, I believe, 2016. Then there was Atwood, 2017, I believe, and Atwood actually expanded to the east a couple years ago. And then Myrtle Grove will be the last one, the most recent one. So we do have the most of all the counties, so we do win that prize.
So a 30-year program represented here in effect, effectually.
Correct. So Warrenton, interesting that the dates are brought up because it is a 30-year plan, and Warrenton is due to sunset in this year in December 2025. So
That was my next question, but I think you answered it. We have not sunsetted a CRA yet?
Correct. We have not, and we have adopted a plan to extend the CRA. However, you'll notice that the upcoming BOCC for September 4th is we're rectifying the issue that we adopted it without a resolution. So we're going to rescind the Warrenton plan and at the same time adopt it again with the resolution. So it's more of a technical, clerical type error. But yes, Warrenton will be the first CRA of the Escambia County that will be extended under Chapter 163 as allowed, that will extend it another 30 years. So
Are most CRAs a 30-year?
Correct, yes, yeah.
Okay.
So Brownsville's next in 2027, so we are interested in extending that one as well. So we have to update the redevelopment plan and use the correct legal language to extend the time certain to meet the requirements of the Florida statutes.
What I'm finding interesting, why in support of this, is we look at, just for instance, like the sewer map. I mean, we have a great, and mind you, it works at the EC way, but we see in the heart of it, which I don't know if we can pull up that map, but in the heart of this Myrtle Grove redevelopment area, we see a massive lack of sewer infrastructure. What the CRAs push for in terms of sewer connection programs is a great aid to this. And when we start overlapping like the safe neighborhoods on top of it, getting additional street lighting, there's a lot of benefits to this once we see the crime, everything like that. Another point, and this one here will be more of a marathon, not a sprint. If you look at where it's at, we look at almost 70% of the acreage, or roughly, give or take, about 3,300 parcels in this are single-family residential or vacant commercial or residential. I mean, it is going to take the improvement programs that are targeted to the individuals in this one versus commercial. So this will be really more grassroots than anything else of a program, but it should hit the individuals, the individual taxpayers in this area, and keeping their money in that TIF fund more than anything else. So that is a good problem to see in this specific area. So my 10 cents into that. But once again, it is going to be, for that TIF fund to start accruing funds, it's going to probably be a good time before you see large capital projects or anything like that come out of this.
All right, any more questions from the board? If not, I've got something that I'd like to share on this. Do I need to have a vote for me to share this with the rest of the board members to add it into? the meeting file, or we don't need to worry about that for this?
You wouldn't need to. It's a
Okay.
public hearing.
All right, so I talked to property appraiser's office, and then Max, I think you got with them as well. I asked for an example of what the taxable value was for this current year, which will set the base year for Myrtle Grove CRA, which is that $329 million. I also asked for what was last year's, just to give us some sort of idea of what revenue will be generated out of this. And again, we don't know what property values will do in 2026, but this gives you some sort of idea. If this was created 12 months ago, what would be the first kind of installment into the TIF? And right now, all of our CRAs have a 75% capture rate. For the increment, counties, municipalities can go anywhere from 50 to 95% capture rate on your TIF financing. Counties at 75. So you see, if this was created a year ago and we were looking at what was going to be brought in, $136,000 would be what would be going into this Myrtle Grove CRA TIF, which is just over 6% of the total amount of property tax that would be collected in that area, which is that $2.18 million there at the top. And then the remaining $2 million would go into the general revenue fund. I've got also on the next page broken out all of the CRAs with their extensions or annexes. You've got in the taxable value in the TIF, that is what is assessed for this current, or I guess as the tax roll on June 1st. And that last sheet is showing that the taxable values that were just put out. So you'll see that the TIF revenue is 75% of the capturing from the base. What is going to be going into each CRA as a payment, and that's set under that 75% column. On the left, to the left of that says general fund revenue. So that's out of all the taxes that are paid, that's the amount of money that is paid in property tax that'll go into the general fund. So you see, out of all the CRAs that we currently have, 10.3 million is going to go into the general fund, 9.3 divvied up among these CRA areas, which still gives you this $19.7 million in property tax, which is what's being taxed under the taxable value in the TIF. My suggestion or proposal would be we can't change, my understanding is we can't change what the percentage of the capture rate is for the TIF and what the county's got already. But I think if we want to move forward and approve this Myrtle Grove CRA, to at least throw the suggestion of for the county commission to consider raising the capture rate in the TIFs to keep more of those property tax dollars in these CRAs, especially for something that's new like this Myrtle Grove one, which back on the first sheet, you can see if you went to a 95% increment in the Myrtle Grove CRA, your revenue jumps from what would be $136,000 to $172,000, and you're still contributing 92% of their property tax that they're paying into the general fund, with 7.9% of it going into the CRA. And again, they can pick to stay where they're at. They can pick to go to 78% if they wanted to, or go down to 50%, or go to 95%. But I think it's worth the conversation. If you go back to the sheet with all the CRAs on it, and look if the county went to 95% capture rate on all of their CRAs, you would have $7.8 million going into the general fund from all those properties, with $11.8 million going into the CRAs. And so again, that might be a conversation for the board to have, but I think it's certainly one that the county commission should look at if we're really trying to invest and develop these areas that are underdeveloped and need some help. So that's my suggestion. Happy to any comments, questions, or whatever you might have.
I actually don't disagree with you in principle here at all, to be truthful. I mean, this is, especially with this one with the income, like if we guesstimate year one, it is going to be a marathon of this. It is going to take a while before it has substantial funds, even a reserve. I mean, and the county's pretty good about not doing bonds or anything like that with their CRAs, which I applaud your department always for that. But, I mean, that is some conversation that I think does merit some with the commission, you know. I will agree with the chair on that.
Anything else? All right. If that's something that y'all are open to as a suggestion to the board, to at least have it under consideration and talk about as a part of your motion, I would appreciate it.
Yeah, that's what I was going to ask, is what does that look like in our motion? Is it a motion to approve with a request or recommendation?
It's probably better to be a request if it be just an action for Max to get with his director and to see how they want to frame that to the board for not the recommendation, because the board controls all of that with laws and policies and state statutes on how that is done. So probably better for a request to definitely have discussion.
If I can make a recommendation.
Yep.
Okay. Okay, under chapter 163.360, section 4, the purpose of the meeting today is for the CRA to bring the redevelopment plan to the planning board for review and recommendation as to its conformity with the comprehensive plan. So that in and of itself is basically what the action is here today. However, it does say that the local planning agency shall submit its written recommendations with respect to the conformity to the proposed community redevelopment plan to the community redevelopment agency within 60 days after receipt of the plan for review. That in your comments, in your recommendation, you could have that discussion, but hopefully the motion we're looking for here today is that the planning board finds the Myrtle Grove redevelopment plan in conformance with the comprehensive plan to move it forward to the Board of County Commissioners for its September 4th meeting. But in your written communication, that would probably be the more appropriate place to mention, and you can provide the backup that if you, different scenarios of TIF capture might be warranted.
Okay. Does that sound fair, Mr. Attorney?
That works.
Okay. All right. And then do we have somebody in the public that would like to speak? Okay. Just want to make sure. Mr. Kerb.
Chris Kerb with Flood Defenders. I rise in support of this. I've worked with Max for several years. I've been to pretty much all his public meetings on this CRA. And I've seen a lot of good done with the CRA funding. If you don't know, investment in your infrastructure, it's a 6-to-1 payback. Bring to mind one project that, and yeah, I mean, it doesn't provide a whole lot of funding, but it provides seed money. Beach Haven project in 2003, CRA with ECUA, they funded a basin study for sanitary sewer and drainage for Beach Haven. It was a pretty good basic plan, concept, and what it resulted in is funding. I guess they're on the northeast phase now, phase 2 of Beach Haven, putting in sewer and drainage improvements. And it has 5 different funding sources, even in phase 1. But it never would have been possible without that initial study done that was paid for by CRA. I believe CRA put some sidewalks in the phase 1 of Northeast Beach Haven, but I'm all for this. Only thing I can say about Max is he's doing an excellent job. So I hope y'all vote to approve this. Thank you.
Thanks, Chris. All right, so if the board's looking to approve, it sounds like we need a motion to approve the Myrtle Grove redevelopment plan, and then as a note or communication to the board that we'd ask them to review the TIF percentage capture rate, or I'm not sure how we need to word that exactly, but the percentage of the TIF, I guess, the TIF rate.
So then I'll go ahead and make a motion that we approve the Myrtle Grove redevelopment plan and also send for consideration, conversation about the TIF rate.
All right, we got a motion. Second, any discussion on the motion? Okay, all those in favor, please signify by raising your right hand. All those opposed? All right, motion carries 5-1.
No, I was in opposition.
Right.
Yeah, okay, 5-1, sorry.
Yes, 5-1, yep. All right, that was the only item we had on the agenda for today. Anything from staff before we leave?
I will just say, next meeting, we just have one ordinance, but it will not be the first Tuesday. It's going to be the second Tuesday, because the first Tuesday is the day after a holiday. So it'll be September 9th.
All righty, so September 9th. Sounds good.
You said we only have one what?
One ordinance.
Okay.
Let's go for the record, guys.
Yep, all
Chris,
right.
Chris says he's adding an item.
All right, good stuff. We stand adjourned.